And Alex Warren on behalf of Mr. Bradford.
Glenn Bradford, approaching the bench.
Thank you.
Your Honor, this is the date and time scheduled for a preliminary examination in this case. At this point, we're unable to proceed. We'd ask the court to remand the district court to domestic violence.
Your Honor, the defense would move to dismiss with respect to count one.
All right, count one is dismissed. I'll continue the defendant's not guilty plea. As to count two, I'll set a pretrial date before Judge Washington for November 13th, 2025, 9 a.m.
Yes.
9 a.m. That's before Judge Washington.
Thank you.
That's good to carry.
Defendant's bond with its conditions will continue. Thank you, sir.
Thank you, Your Honor.
Court does call the case People versus Michael Jones Fuller.
All right, lock in. This might look like routine court business, but don't blink. What starts as simple scheduling and dismissed counts quickly turns into something much bigger. Missed procedures, added charges, jail calls, and judges quietly weighing trust versus control. Watch closely, because the smallest courtroom moments often reveal the biggest legal consequences.
Assistant Public Defender Sandra White on behalf of Michael Jones Fuller.
Your name, sir? Michael Jones Fuller. Thank you.
Your Honor, this is the date and time scheduled for preliminary examination. At this point, we are unable to proceed with count one. That's single count of the complaint. We would ask the court to add a count two as interference with electronic communication under MCL 750-540-58, and then another 8 for attempt. So 1 year misdemeanor and or $500 fine. Your Honor, I'll make sure that an amended complaint is forwarded to the court and counsel.
All right, if you could give me that PAC code again. 750.
750-540, subsection 5, subsection 8, and an additional 8 for attack.
Got it.
Your Honor,
Yes.
we agree to the dismissal on the felony. We ask that you don't remand on the misdemeanor. We don't believe they've had any contact with the victim. Mr. Jones Fuller is facing dismissal from his job. He's taken lots of time off from his job. And we believe that it's unnecessary for them to try to continue this matter.
Okay, so are you not? So you're not waiving presentation of the complaint at this time?
Correct.
Okay, and I'll need a complaint prepared and I'll send it down because I'm going to send it down either way. I mean,
Okay.
because otherwise here's what will end up happening, which will maybe be even worse for the defendant, quite frankly. If I dismiss it outright, we're just going to reauthorize it. He can get arrested again and then the whole thing starts. And so, I get it. There aren't good choices on it, but
I did explain that to Mr. Jones Fuller.
So what I'll do is I'll pass it. We'll await the complaint.
Okay, we'll go forward.
Pardon?
We'll go forward on the remand, Your Honor.
All right. So you're waiving presentation at this point and reading of that?
Correct.
All right. As to count two, I'll indicate that the defendant, and how does he plead not guilty to that charge?
He pleads, we waive formal reading and we plead not guilty.
All right, defendant pleading not guilty as to count two. And they will file the complaint with the court, but we'll set a pretrial date on that matter for
November 10th at 9 a.m.
November 10th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Defendant's bond, that's the only date we have for Washington, correct?
Yes.
Okay.
Thank you, Your Honor.
I was gonna try to just push it out so that if he had to tell work, whatever, then, but I don't have another date.
Okay.
Right?
You remand?
Is he remanding? Oh, no. Why, you want to take him? You want to take him? No. She heard me say remand. Like she was, that's
She was ready.
about Lee. She was ready to go. You were going in. If I wasn't here, sir,
He's scaring
that would have been it. Then I,
Yeah, but you kept whispering something. I was wondering what he was saying.
and I'm like, well, whatever, Mr. Jones Fuller. I don't know. See, I stopped it. All right, you're welcome. You take care, sir.
Sorry about that.
But no, if you had told me, should you take Miss White, I would have said, yeah. Okay.
And you want to have one with Mr. Gaddy? He's patiently been waiting.
Not, well, patience is relative. He's been saying all kinds of things while you weren't here. It was horrible. It was horrible. I had to tell him to stop. You know how Gaddy gets out of control. So what are we doing?
I don't know.
Oh, so it's going to be a mystery.
I think she indicated she was ready, yeah?
Yeah.
Yes, we're going to Salty Palmer and we're going to be requesting an adjournment.
Okay.
Just.
Good Lord. Okay, we'll send people. Let's see. We'd like a They almost got some excitement if Lee had her way. Court does call the case, people versus Romaine Palmer.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Palmer, who's making his way up to the podium.
Your name, sir?
Romaine Palmer.
Thank you. What are we doing?
Your Honor, this is the date and time scheduled for preliminary examination. However, we are missing an unnecessary witness. Your Honor, this is a case that was up previously. There is a great deal of concern because this defendant has contacted the victim in this case. At the time that the jail calls were listed to, originally at that point 43 calls since arraignment. I believe his phone privileges were revoked by Your Honor at the last hearing. And that Your Honor indicated that you would allow motion for forfeiture by wrongdoing if that would be necessary. We are here today. The victim is not present. Ms. Zenda has listened to the jail calls. We have a description of the jail calls. I was able to forward those, or at least a link was sent to Mr. Gaddy yesterday. Get Mr. Gaddy and myself yesterday. Essentially, on the jail calls, as my understanding, there's clear instructions to the victim from this defendant on what to do, what not to do as it relates to cooperating with prosecution, details on how to dismiss the case, telling the victim to contact the prosecutor's office and tell us that she is not pressing charges, to tell us that they only got into a verbal argument. I could go on and on. There's plenty there, Your Honor. Needless to say, the nature of it, we believe, a good basis for a forfeiture by wrongdoing motion. And so we would need some time to file that. I'm sure Mr. Gaddy needs some time to listen to those calls as we were only able to provide them to him yesterday.
So that's correct, Your Honor. We did receive those yesterday. I believe they were downloaded this morning. I have someone doing a preliminary listen as we speak, but I have not heard them. Looks like the calls, I think his phone privileges were revoked some time ago. We're prepared to go to exam. I understand the people are asking for an adjournment, and we'll leave that to the court's discretion, given the fact that they would probably reauthorize. And if the case were dismissed, he would lose any credit for any time he's got it going now.
Revoked his phone privileges once knowledge came to the court on October 9th. And at that point, there was contact. I don't think that it was specifically told to me what all the substance of the phone calls were. I'm a bit disturbed by what I'm hearing today regarding that. I will grant the people's adjournment for a preliminary exam date in this matter. I'll adjourn it to my next available date where I'm not covering, but to give them time to do that. Will be adjourned to 11/25/2025 at noon.
Yes.
And at any point, I can hear the motion once it's filed on that.
Thank you.
Defendant's bond will continue. His phone privileges remain revoked. Thank you.
And Your Honor, if we were to file a bond motion or release any kind of a modification motion, that would be before your honors.
Yes, it would be. And I would indicate, certainly I will hear any motion, but if I were to see something where it appears that the defendant is interfering with these proceedings, it's going to be hard pressed to release. I think you know that, Mr. Reddy.
Yes, thank you.
All right. Thank you. That's for jails. Okay.
When prosecutors revealed the defendant made 43 jail calls to the victim, everything stopped. The courtroom fell silent as the judge realized he'd been coaching her to drop charges. The verdict. A powerful reminder, the truth always finds its way out.
She's trying to sneak out. Court does recall the case of the people versus Michael Russell.
Another water assistant prosecuting attorney to the people.
Assistant Public Defender Chelsea Virgils with and on behalf of Michael Russell, who approaches. Mr. Russell, please state your name.
Michael Russell, for the record.
Your Honor, thank you for passing this to allow me to speak with my client. I have provided the court with a preliminary exam waiver form. I believe Mr. Russell is very much aware of his right to a preliminary exam. There has been an offer by the people in circuit court that he is interested in, so we are asking to waive his preliminary exam.
Did you wish that offer stated on the record?
Yes, Your Honor.
Thank you, Your Honor. If this matter went to preliminary examination today, the people would be seeking additional charges of resisting and obstructing, causing injury, as well as potentially one other additional count of resisting and obstructing. Pursuant to Mr. Russell's waiver and plea of guilty to the existing current counts 1 and 2, the people will agree not to seek additional charges. Further, the people will also agree that he may plead no contest to those existing charges 1 and 2 on the issue of potential civil liability, and the people would further agree to a sentence of probation with no prison term. Any jail term would be up to Judge Hammoud, before which Mr. Russell would be sentenced.
And a correct statement.
That is our understanding of the plea.
All right, Mr. Russell, you're going to waive your right to a preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Understood, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts. Ms. Virginia.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
November 3rd at 1:30 with Judge Hammoud.
November 3rd, 2025, 1:30 before Judge Hammoud.
Your Honor, may I address bond?
You may.
Your Honor, we're asking for a personal bond in this case. This is the only thing holding him at this time. My client stays in Washtenaw County. He has an address with a relative he can stay with. He has a good relationship with his family, has been in communication with his mother, who is supportive of him. He also helps take care of his father, who is at a senior center in Milan. Close with his siblings as well. He's employed in construction and cleaning, has his own business. He really wants to get back to that. Of utmost concern to my client at this time are his health issues that he is suffering from. He has high blood pressure, which can be very dangerous, and is had a recent fall at the jail that severely injured his back and neck. He believes he needs to go to the hospital. He would like to seek medical treatment for that urgently outside of custody. So to be with his family, to continue work, and to seek that medical treatment, we're asking you to consider a personal bond.
Response.
Your Honor, the people would object. Facts of this case, Mr. Russell was found trespassing at a lot in Ypsilanti. Officers observed him as someone who matched administration had been there the night before and was believed to be stealing items. When the officer sent to stop, he ran. Additional officers arrived on the scene and chased him. He hopped a fence. 2 officers hopped that same 10-foot fence, dropped down. The officers were injured. One in particular suffered scratches on his arm as a result of this. Mr. Russell still refused to stop. Eventually, he had to be tased in order to stop him, and then he was taken into custody from there without further incident. This is not the first time that he has gone with the police. He has a history of resisting, fleeing, and lootings. He's been sent to prison for this on multiple occasions. While we have reached a resolution in this matter that does not involve prison, the people believe that he should be released after this case is ultimately resolved with the proper safeguards and guardrails in place so that he can maintain whatever his issues are and get those under control before his release.
Anything from?
Yes, Your Honor. Although he is interested in that plea deal at this time, the allegations remain allegations. This is the only thing holding him. I believe Mr. Russell would attend future court dates and fully intends on complying with any probation he's sentenced to. I would ask the court to consider release on a tether, if not just a personal bond.
Well, given the fact that they said, alleged that officers were injured, but also he does have a history of flight from authorities, the court would consider him a flight risk at this time. I'm going to deny your request. Certainly, Judge Hume can take a look at it and make a determination as to how she wishes, if the defendant's released, how he would be released in the circumstance. So, motion's denied, bond will continue.
Thank you, Your Honor. Have a great day.
Thank you. You too, sir.
It began like any routine hearing, then came the revelation. 43 phone calls, hidden from the court, exposed live before the judge. The defense scrambled, the prosecution pressed, and justice suddenly felt very real. This is what happens when the truth hits the bench.
What's your best hand? Of course, everything I had left is mistake. I didn't say that badly. I just said that because we have to wait and see what happens.
I got my tape.
Huh? Or your Pumas? I got my Under Armour's back there. So I'm ready to run. Court does call the case of the people versus Kamani Barfield.
Good morning, Your Honor. Mary Tennis as the prosecutor. Attorney on behalf of the people. Just an attorney.
Yes. Sorry, Assistant Public Defender Chelsea Vergils on behalf of the defendant. We are asking to adjourn.
Sorry, I thought that she was here. I'm so sorry.
Is she? I don't know.
She wasn't here. Oh, I'm sorry. Okay. I apologize, Your Honor. Someone can track her down. She was speaking to Mr. Brown.
Oh, okay. All right, I'll pass it. She's out though, right? I'll pass. Mr. Brown left?
You already came on. Go check.
Yeah, that's right. Come on, Bishop, get on it.
Oh, thank you. Sorry. Okay. She's it's like sometimes they are, sometimes that's the that's just I call her off in one country. I don't think she's
What did we just witness? Not chaos control. From dismissed charges to tightened bonds, from hidden jail calls to judges drawing hard lines, this courtroom made one thing clear. The system notices patterns. And when the truth surfaces, everything changes fast. Drop your thoughts below. Which moment stood out to you the most?